Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, my friends. I hope everybody is well today. I hope you are all staying warm. A little advice from, I don't know if I can wear this hat. Or maybe, is it the camera that's in my way today? I don't know. Something's in my way. Anyways, from a Canadian who lives in a place where it doesn't snow, to Americans who live in places where it doesn't snow. Stay home, my friends. Stay home. Explore your backyards if you have children, but don't drive if you can avoid it. It is best left to somebody else. Seriously, you won't miss anything. I swear. Seriously, I do hope that everybody is doing well, staying safe. You know it's serious when Ryan Hall, y'all, is out there talking about 2 inches of snow. I know it's more than that in some places, and I know, like I said, I come from a place where we don't get snow very often. Even though we're in Canada, we're sort of like the joke. And the reality is we're not prepared either. So when you're not prepared, just stay home. Dig something out of your pantry, cook something, find a movie to watch, but don't drive. It is way more difficult than you think. And that's with your cars equipped properly, which most of them aren't. Anyways, so that is my rant about driving in the snow over. Seriously though, please stay safe. Sorry, I'm just getting a message. Okay. But we have court today. Court was in session. All the people up in Michigan and Minnesota were yelling as loud as they could in the Ryan Hall y'all chat. Hey, where's our snow? Why did the South take all of our snow? I swear to God, I watched it happen. Anyways, but I did manage to capture us some court. I wrangled it up. Oh, what was the order? I started with that one. Okay, so let's start here and then we'll go from there. Sir, Kyle McDermott, where are you appearing from? The McDermotts are getting divorced, you guys. Does she have a duck face, or is that just like... Oh, did you see the hair fix?
Circuit Court
Hold on!
With the Honorable Brian K. Kirkham presiding, calling case 2024-3394 DM, Brianna McDermott versus Kyle McDermott. Today is Tuesday, January 21st, 2025 at 9:26 a.m.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, defendant appearing in pro per. There are 2 matters before the court: the plaintiff's motion for temporary custody, parenting time, and defendant's motion to determine child born out of wedlock. We'll address Mr. Todd's motion first. I guess I'll ask Mr. Derman, in consideration of your motion, are you contesting or disputing custody or anything?
Your Honor, I'm disputing the custody of the oldest child.
Okay.
Oh
Okay.
God, oh
Then,
God, oh God. Spicy. We have a child born out of wedlock. MB is ready. Yes. MB is ready. Look at her face. I don't know if it's the angle, but it is not a good look, ma'am. You are looking smug as a bug in a rug when it seems like you may have played around outside the marriage, that is. Oh. Also, let's see. Let's just see. Smell the fart face? I don't know. It looks like pleased with herself face. Can I do that? Hold on. I gotta put on some lipstick or else we won't be able to see it. She probably does suck good dick. Maybe, maybe not. Maybe not. That's gotta dry, so let's continue.
Go ahead, Mr. Todd.
Thank you, Your Honor. Your Honor, the parties separated in September when a PPO was granted. Since that point, the PPO has in fact been violated. Since separation, defendant has had no contact and no parenting time. The motion actually is not necessarily accurate at this point. Mr. McDermott did request some parenting time in late November. And my client indicated that that would be fine as long as it was with a third party neutral, or alternatively, it could be supervised by his mother. We do believe it's in the best interest of the children for mother to retain sole legal and sole physical custody, with parenting time only being supervised. We've outlined those reasons in the motion. Defendant has not spent one overnight alone with the children ever, including prior to separation. Defendant has significant anger issues. He has chased one of the children up the stairs, saying he will beat their butt.
Beat their butt? Come on, Wesley. This now is not the time. Brooklyn, divorce for ya. Look at that. Not a full one, I'll be honest, but I got a little something for you. A little something, something. Both of them have terrible camera angles. It's just, ugh. Ugh. Also, I do want Wesley to swear in public. Chase the kid up the stairs and said, I'm going to beat your ass, but did you beat the ass? That is the question. Right? Because America, I think, well, free speech is one thing, but threats don't fall under free speech. But there's this weird gray area underneath parenting and discipline.
That child was 6 years old. We have a recording of this. Additionally, defendant has a pretty significant criminal history. He pled guilty in 2023 to assault with intent to do great bodily harm less than murder. During this particular incident, he was drunk. He forced plaintiff downstairs, holding her hands behind her back, and began to choke her while she was calling 911. And also he had a hatchet and was threatening her. Defendant has uncontrollable fits of rage and anger. Additionally, he cannot provide a stable or consistent environment for the children in any way. In June of 2024, there was an incident where he was drunk, put the children in the car, and then proceeded to do burnouts. In July of 24, there was an incident where a defendant threatened to murder someone. The children woke up.
Bro, can you say unalive, please? I'm not joking. Fucking 10 out of the last 15 live streams have been restricted for monetization. And you're not helping me, Wesley. You are not helping my case right now, bro. Please.
During this incident, and then defendant started to yell at the children. Later in July of 2024, there was an incident where defendant was drunk, yelling at both plaintiff and the children, calling them pussies and saying that he would teach them a lesson. We have a recording of that. In August of 2024, there was an incident when defendant was drunk. He cut off the power to the home, and plaintiff woke up. Defendant had jelly covered on his face and was holding a knife.
Whoa, 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 whoa. I need a little more info. Parson, apparently we're talking about one child. There's one child that's born in the marriage but is not subject to the marriage, is out of the marriage. We haven't, all I've heard is this that we've heard right now. Are they talking about KY jelly? Are they talking about strawberry jelly? Are they talking about, what are they talking about? What kind of jelly are we talking about? Yeah, Kyle, you're doing too much, bro. You need to, like, dial it back. Hi, William. Holly's getting out of the tub soon. Love it.
We have pictures of this incident as well. Given additionally, there was a hit and run, which defendant admitted to, and we have this in recording. Given all this, we believe it's appropriate that he obtain a psychological evaluation and comply with any and all recommendations prior to any unsupervised parenting time. This behavior is continuing to get more aggressive and worse and uncontrollable. Alternatively, my client is a stable income as a teacher and a stable home for the children, has a strong connection with the children, and we are requesting child support to be backdated from the date that we filed this. So in total, we're requesting sole custody be given to my client, defendant complete a psychological evaluation and comply with any recommendations prior to unsupervised parenting time, but he can have supervised parenting time through a third-party neutral, or alternatively, his mother, and we would respectfully request that that be limited to 3 hours per week.
Okay, thank you. Mr. McDermott, what's your response?
Your Honor, well, she's accused me of being extremely intoxicated multiple times, even to the point where telling my parents that I'm drunk in the driveway. And my dad actually would come over and make surprise visits and find that I had not drank anything. I was not drinking during the burnouts.
Oh, what a terrible, oh. Oh, this is why you need a lawyer, guys. Kyle needs a lawyer. Kyle is stupid if he doesn't have a lawyer, okay? Because the lawyer could say this, but it doesn't matter what he's gonna say. He just let it out of his mouth that he did burnouts, ostensibly with the children there. That's not gonna help, bro. That's not gonna help. God. Seriously, people, get lawyers.
When I got arrested for putting my hands on her, I went through the entire program, and she dropped the charges at the day of my court date, and the state picked it up. I went through their entire program, was released off probation early, and I was even offered a job. The reason I've had no overnights is because I don't quite understand the PPO, and I was seeing my children at the house up until 11/17/24 when the talk of splitting items and divorce came up. And I do have this on recording. And then 11/24, she had canceled on me. I had a visit on 11/25, a video visit. And all these incidents where apparently I was drunk and obscene, my question is, how come the police were never called then if I was such a danger? And I apologize, Your Honor, for this, but I did actually go to Berry County mental health and had an evaluation done, but I didn't get my letter back until Saturday, so I wasn't able to send out the appropriate copies. But I do have that, and I was going to send those in today.
Great. Thank you. Anything else, Mr. Todd?
No, Your Honor, but I guess just the PPO does allow for peaceful contact as it relates to the children.
Well, what the court will do in the interim, the court will grant to the plaintiff legal and physical custody support pursuant to guidelines to the date of notice of your motion, Mr. Todd. Court would allow supervised parenting time for up to up to 5 hours on Saturday from 12 o'clock noon to 5 o'clock PM. That can be exercised at his mother's home or at some other third party that the plaintiff would approve and agree to. And Mr. McDermott, you'll have to provide that psychological evaluation to Mr. Todd within 7 days of today's date.
Yes, Your Honor.
That will take care of that part. Mr. McDermott, now we'll address your motion to determine child born out of wedlock. Go ahead, sir.
Well, when I had met the plaintiff, she was already pregnant, and she kept his real father out of his life for about 2 years. And after that, I mean, he has been seeing him all the time. He's over there almost every weekend. And I just don't feel it necessary for me to have to pay support when his real father is seeing him consistently. And as far as me signing the birth certificate, be honest, I really didn't even know what I was signing.
Yeah. Well, that's unfortunate. Okay. Mr. Todd had filed a response which was consistent with what this court had was thinking when I found this. Mr. McDermott, pursuant to the statute, which is 722.1441, you're required to take action and file your action within 3 years of the child's birth. Child's 8 years old, so you've missed the statute of limitations for filing this action. What's your response to that, sir?
Your Honor, I was not aware of that.
Okay. Well, unfortunately, whether you're aware of it or not, it's still the law. And as a result, the court can't just ignore the law because you weren't aware of it, unfortunately. So the court doesn't find any basis at the current time for your motion in this matter. So I'm going to deny and dismiss the motion. I'll ask Mr. Todd that you would prepare an order to that extent, as well as a motion on the other the matter. It might be better if you did them separate, that way.
Sure.
Rather than just one order.
Okay, absolutely.
Okay, that will be the ruling of the court, and you're free to go and have a good day.
Oh, I apologize, Your Honor. One other thing, can I request an exchange of income within 7 days?
Yes.
Okay, thank you,
Okay.
Your Honor.
Yeah, Mr. McDermott, send to Mr. Todd proof of your income, and he will send the same to you as proof of the plaintiff's income.
Yes, Your Honor.
Okay.
Well, that went sideways fast. Again, folks, get a lawyer is the best advice we can give you. Wow, judge handled that quickly. Also, if you're in Michigan and you think that might not be a baby, you're going to want to go ahead and file that motion within 3 years. Unusual, because normally, I guess so, William. True enough. We do need the content in a way. Sorry, I'm just checking the order here. Oh, I fucked the order, apparently. But that's okay. Let's do it anyways. Shall we? this one, and then we have 2 short ones after it. We'll see how short this one. Oh,
Good morning, Your Honor.
good
You can
morning,
proceed whenever you're
guys.
ready.
Hold on.
Thank you. Before the court is Nicholas Beals of case 222730DS. Mr. Beals is here today after failing to appear before this court on July 10th, 2024. Bond is currently set at $3,737. This is the second bench warrant. He reports no employment. Last payment made on this account was on November 25th of 2024. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on January 29th, 2025 at 8:45 a.m. before this.
Mr. Beals, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond to assure your attendance at the next hearing on January 29, 2025 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not. I just moved back down from Charlevoix because I was in rehab.
From where?
At a
Hold
sober living
on.
house.
Charlevoix? Is that what he said? Charlevoix? Also, these are not gummies, MB. These are true freeze-dried raspberries covered in chocolate, 2 layers of chocolate. I tried them last night. I became addicted. You can watch it happen in real time. And just like any addict, I ran back to my dealer, Walmart, and I purchased more. I wish they're sugar-free, Brooklyn. No, these are not sugar-free. They are 290 calories per package. Last night we counted there was 6 raspberries, and they were fucking delicious. I thought this one was ripped. Oh, it is. I better eat it fast. That just means I better open it now.
House, and then I came down here and I just put in my application for WSI for EPI. So I'm supposed to start Monday.
Okay. Well, you've got a sizable arrearage, so the court's taking that into consideration, but you have 2 prior bench
hold
warrants,
on.
and
It's probably
but you
echoing.
have recently paid.
Hold on.
So your arrearage is pretty substantial. I mean,
I apologize. I'm sure that was echoing because my dumbass didn't pay attention properly. So I apologize. Put these in the freezer. They're amazing frozen. You guys, there's really big ones in here. We got some big papas. I love it when I call them Big Papa. Okay. Look how cute they look. Oh my god. I'm gonna get fat eating these. Super fat.
your arrearage is over $15,000.
Yeah, I know. I talked to my ex-wife and she said that she plans on writing off on half of it because I guess that's like something she can do is write off on half.
She can waive any amount that's owed to her, but not to the state of Michigan. So
Okay.
if she does that, that'll make things better for you, obviously. What I'm gonna do is I am gonna reduce your bond in hopes that you could be released. I'm gonna set your bond in the amount of $500. If you're able to post that, you can be released. Do you have any questions?
No, sir. Thank you.
Okay, thank you. You're free to go. Have a good day.
You too.
I need a drink. I'll be right back. Judge, can you handle this? Oh my god, you guys, these are not big balls. Take that as you may. I got some giant balls in this house.
Now, excuse me. Now before the court is Thomas Wise of cases 092734DP and case 111915DS. In each of these matters, Mr. Wise is here today after failing to appear before this court on April 10th, 2024. In the 2009 case, bond is currently set at $1,400. This is the 10th bench warrant. In the 2011 case, bond is currently $2,828, and this is the 9th bench warrant. He reports no employment. Last payment made on these accounts was in September of 2021. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on January 29th, 2025 at 8:45 a.m. before this court.
Thank you. Mr. Wise, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 29, 2025 at 8:45 a.m. Are you able to post bonds, sir?
If it's low enough, yes. I mean, hopefully my family can. I'm not sure.
Well, you've got obviously you've got sizable arrearages in these particular cases, and you've got, in one instance, you've got 10 bench warrants, the other one 9. So you've got a history of not appearing. I am going to reduce your bond and hope that you could be released. But what I'm going to do is set your bond in each case in the amount of $500. So if you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
To be clear, most of these people are in jail for failing to appear at a hearing with a child support officer and then not being in communication with the court. This court is extremely lenient. I know it seems like they're not. They are. They are recalcitrant. I don't think that's the right word. I think it is actually, but to jail people, all you have to do is apply to like 10 jobs a week or something, and then you're free to not pay your child support in this county, allegedly. Anyway, basically they're just very, very hesitant if you're in communication with the court. What happens though is if you don't show up or you like flout the court to their face by ignoring them completely, and again, not being in communication with the court, you're gonna get bench warrants issued. That's my theory. Lenient, yeah. I just think they're like very hesitant. Recalcitrant, I think is the right word, but I'm gonna look it up.
And I've got a couple of bench warrants for the record, if I may.
Okay.
Richard Kopic of case 17113.
Well, I think it could work, but it might not. So recalcitrant means having an obstinately uncooperative attitude towards authority or discipline. And actually, I do think it exactly works here because they have the authority and they choose to not exercise it. My theory, like what I'm trying to say is the court could be much more strict about enforcing this type of thing, and they're not. Obstreperous, I like that. Haven't seen it. Let me look it up. Obstreperous. I like that. I love new words. And hi over it. How are you? Noisy and difficult to control. That one, it describes me. I love that, MB.
34 DM. Ernest Dickey of case 88973 DP. Larry McComb of case 231058 DS. Tavion Stein of case 161832 DP. Gil Young of case 132392 DP. And Theodore Brooks of case 161569 DP. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter bench warrants for Mr. Kopic, Mr. Dickey, Mr. McComb, Mr. Stein, Mr. Young, and Mr. Brooks as a result of their failure to appear at their respective referee hearings. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor.
Okay, thank you. You have a good day.
Thank you. You too.
Thank you, Jeff. Take care.
All right.
Thanks,
See you,
Mr.
Jesus.
Chapman.
See you.
Okay, Jesus, what you got? We got two more quickies. Again, being in contact with your friend of the court person is
Okay.
very helpful. Oh my goodness, I thought her name was Booger. At first glance, I thought it's Booger. I don't think it is.
My apologies, Wes.
No, no problem. We appreciate just being able to get this done.
Okay, so I need to make sure that can you speak to us, ma'am?
Ms. Bugard, do you hear us?
I couldn't hear you.
I can
Can
hear
you
you
hear us
guys.
now?
No,
I can't hear you.
she cannot hear us, she says.
Can you turn up your volume?
I heard the judge.
Okay. He's saying turn up the volume if you can.
If she can hear the judge, though, that's weird. The volume is not per person. Wouldn't that be great if you could just mute
My
Well,
volume
one
is all the
person?
way up.
Why don't you speak, Mr. Todd, and see if she
Yep.
can hear you?
Sure. Tori, can you hear me?
No? I'll just do it. I'll swear her in, I'll do it.
Okay, let me get the record open for this one, call the case number. Okay, this is case number 2024-2065 DM, Victoria Bugard versus Kyle Bugard. It is Tuesday, January 21st, 2025 at 8:40 a.m. Attorney Todd is for the plaintiff.
Ms. Bugard, we're going to take some testimony from you, so we'll need to have you raise your right hand, be sworn in, then we'll proceed. Please raise your right hand, man. Ms. Bugard?
Did you hear that?
Ms. Bugard, can you hear us? Ma'am?
Why is it
Something's wrong
so
with that
funny?
Ms. Bugard, can you hear us?
Judge, obviously she
Can you hear
can.
us yet?
Hi.
I wonder.
All right,
Have her
Victoria,
call
why
the
don't you put
phone line,
yourself on
maybe.
mute and I'll put you on speakerphone. Okay, she's on speakerphone now.
Okay, Ms. Bugard, can you hear us? I can hear you. Okay, can you hear Mr. Todd?
Yes.
Go ahead, Mr. Todd.
Thank you, Your Honor.
She hasn't.
Oh, I thought you swore in.
No, because, anyway, just please raise your right hand so we can swear you in. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
There we go.
Go ahead, Mr. Todd.
Thank you, Your Honor. Ms. Bogart, do you remember signing a complaint for divorce? At the time you signed that complaint, were all those allegations true, and do all those allegations remain true today?
Yes.
Did you live in this state for at least 180 days in this county for at least 10 days prior to filing the complaint?
Yes.
Have you had an opportunity to review the proposed judgment and believe it equitably divides all of your assets and debts?
Yes.
Are you currently pregnant?
No.
Have you had an opportunity to review the custody, parenting time, and child support provisions? and believe
Okay,
they're in
first
your
of all,
children's
stop.
best
The
interest?
cat is in. It's a cat. It's official. It's in. Look it. We can watch the cat come in. Secondly, Erica, have a good night. Thirdly, that's not what I expected for Mr. Booger. Fourthly, where's my joint? How did it... Oh, I found it. I found it. We're fine. Yeah, those are brand new curtains. Good eye, MB. G-O-O-D-E-Y-E. Good eye, good eye, good eye.
Assets and debts?
Yes.
Are you currently pregnant?
No.
I don't know, lady. The cat is looking at you like, bitch, I saw you pissing on a stick this morning. What the fuck are you talking about? Look at that cat. It looks like it's seen shit.
Have you had an opportunity to review the custody, parenting time, and child support provisions and believe they're in your children's best interest? Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Would you briefly describe for the court why that is?
We didn't see eye to eye.
Nothing further, Your Honor.
We don't see eye to eye. Do you have to see eye to eye in order to be married? I didn't realize that was part of it. I guess if you can never agree on anything, that would suck. This is so weird. The cat was traumatized seeing them have sex, probably. I want more tea, boogers. Come on. More.
Is this Mr. Bugard?
Bogart, yes.
Mr. Bugard, in this matter, we simply took some proofs that we have to take. It's kind of a pro forma thing, but I want to ask you, are you contesting or disputing anything, sir?
No.
Okay. Thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the approved judgment and the UCSO and the approvals from the front of the court. When we have all those documents, then we'll be able to complete the case. So you're not divorced until I actually sign the paperwork. So it still may take a couple of weeks or so to get all of that completed. But I wish both of you the best of luck. I hope everything works out for you. You're free to go today and have a good day.
Thank you.
All right.
Thank you, Your Honor.
Yeah. Again, I'm really sorry, Wes.
No, it's all right. Totally fine. Thank
Okay.
you. And we're working on getting FOC approval today, actually. So
Okay, very good. We're keeping an eye on that. Do you
Thank you.
have any hearings, any motions?
yeah, but not until
Yeah, he does.
later.
Okay, all right. We'll see you then.
We'll see you then, he says. Okay, we have two more short ones, you guys, for tonight. Dragging it out like a dragon. Let me look at the order. Sorry. 556. 556. 556. Courtney, you seen any snow? Just coldness? Craziness? Jesus is always friendly. I like him. Does his job very well. In fact, most court staff that we hear does do their job very well. Okay, now we got angles again. Matthew, like me. Oh, I was like, he's trying to get that down angle.
Is now in session with the Honorable Brian K. Kirkham presiding, calling case 2021-3007 DM, Elizabeth Klein versus Matthew Klein. Today is Tuesday, January 21st, 2025 at 9:38 a.m.
Court will note the appearance of Ms. Oatman on behalf of the plaintiff, Ms. Green on behalf of the defendant. This matter is before the court on the plaintiff's motion for entry of money judgment. Ms. Oatman.
Yes, Your Honor. Mostly I will rely on what we stated in our motion. I would just like to add a little bit more clarifying information. With this safe, there was no key brought to the exchange, and we're not actually disputing the fact that there were items brought to the exchange, but all of the items were non-functioning. No key was brought for the safe. The dead batteries are inside. It is not a fingerprint or otherwise biometric type of safe. Therefore, it was inoperable in the way that the defendant was ordered to bring items. He did not bring the key to that. For the drone, he refused to fly it at the exchange. My client had to order parts to even get it charged. Once she got it charged, then she found out it had a fatal error message. Same thing with the RC cars. A subset was brought to this exchange, but my client was desirous of finishing this mess. And so she
And
didn't
so, yeah,
fight over
wait
the
a
fact that they
second,
wanted-
Alyssa. When y'all be fighting over your toys, literally your fucking toys, RC cars, and a drone, go buy a new one, bitch. If you want to be done so much, go buy a new one. Could you imagine? Like, I get it, but this just seems ridiculous to me. Again, how much money have we spent on litigating this? How much money are we paying Alyssa? Could you buy a drone with that? Just a little thought, you know? Just a teensy little thought. But before I move on, don't fuck with people's shit if it's theirs and you need to return it. That's also not cool, Matthew. Don't be a fucking asshole.
All there, including $800 controllers that should have been there. And the parts were, again, non-operable. My client had to order chargers that were appropriate for these devices. And once she got those parts, another fatal error message. So we are asking the court to grant us the money judgment in the amount that we've requested so that she can replace these items. And I believe that would satisfy this part of the parties' disputes.
Okay, thank you. Ms. Green, your response.
Yeah, so there are 3 items, Your Honor. One is these RC cars. Ms. Fogel had the option to choose 2 of them. Mr. Klein brought bins and bins and all of the cars that they had, all the accessories. We provided pictures in our exhibits of everything that he brought to the exchange. Ms. Fogel picked her 2, was able to test them, Mr. Klein gave additional accessories that weren't even required. He said, take whatever you want. He gave her everything for the cars. Regarding the handgun safe, it is located inside the security safe, which Ms. Fogel has had now for over a year. The issue is that the handgun safe is located inside a security safe that at this point, neither party is able to access. Mr. Klein said, look, I think I can help you. I think there's a backdoor into this, but you got to bring the safe. I don't know exactly. I haven't seen this in over a year. Ms. Fogel didn't bring it to the exchange. Mr. Klein does not have a key. At this point, he says, look, go ahead and destroy it. I don't know what you want me to do. I don't have a key and I don't have a way into the security safe for you to have the access to the handgun safe. In terms of the drone, he brought the drone, he provided it. It was in working order when he gave it to her. It's now 5 months past the parties' exchange, which occurred in September. This is the first time that a motion's been filed. We didn't hear anything from counsel. Ms. Fogel didn't reach out to Ms. Klein. Everything was in working order 5 months ago when Mr. Klein provided everything to Ms. Fogel.
Okay. Ms. Oldman, what's your response? He's saying that I brought all the RC cars. She could pick anything she wanted, and this is what she picked.
He did not bring all of the component parts and accessories. There were 2 $800 Futaba controllers that were specifically not brought to the exchange. He told her he would have appropriate adapters shipped to her for charging. She was not able to test those devices at the exchange. When she ordered and received the appropriate adapters, which all took a significant amount of time, that's when she found that unrecoverable error. As far as the drone, it wasn't working. And the safe, it was not inside another safe. He was supposed to bring the key. He did not bring the key. He failed to bring the things in operable condition, and that is our complaint.
Well, in this case, the court will note that the court had...
Hold on, Judge. Before you note, let's guess. Because this is up in the air. We have 2 attorneys arguing over this. Unfucking believably. Then you have me, a YouTuber, reacting to this. And then you have you, a viewer, watching me react to it. Crazy. Crazy. A partial D, MB. You think. So really now, and I haven't seen these attorneys before in front of this judge. So hey now, Christopher Engleby. So nice to see you. I hope you're staying warm. I hope everybody's staying warm. I keep saying that. Oh yeah, we're also mocking the shit out of them. Absolutely. Mocking the absolute shit out of them. That's the way I like it. These people are fighting over toy cars at this point. $800 controllers? Yikes. Anyways, -20. Oh, fuck. That's cold. Holy shit. So my guess is that the judge, okay, what is he going to do? He is going to, he's going to kick it. He's gonna kick the can. That's what he'll do. He will he will find a way to walk the middle instead of making a decision, kick it down the road. That's my guess. Let's see here.
Entered an order after hearing on 9/16/24, which stated personal property not exchanged on 9/3/24. The court shall award money judgment in the amounts outlined in paragraph 5 of the plaintiff's motion. And it appears that there were some items that were brought.
Update. Grim, first of all, 14 months. Thank you so much for the support. Secondly, you have my cat watching me watch you watch court. Oh, shit. Thank you so much. Listen, I would have more respect if these people were fighting over Beanie Babies.
There's a dispute as to what's operable and not operable. The court's not going to get into that. There obviously doesn't appear. What the court will do is the court will grant the plaintiff's motion in this particular matter as to the property, either that was not exchanged or the property that was not operable as exchanged. And the court will enter that judgment, and that.
Christopher, you're amazing. Thank you so much for gifting. At the exact moment I bit into this delicious heart-esque shaped chocolate covered freeze-dried raspberry. So what did the judge just do? We gotta pay attention. Oh, well, people pay court costs, Brooklyn, but yeah, some of the cases have to be covered by the taxpayers, but these are civil cases.
What the court will do is the court will grant the plaintiff's motion in this particular matter as to the property, either that was not exchanged or the property that was not operable as exchanged. And the court will enter that judgment, and that judgment will incur interest at a statutory rate from and after September 3rd, 2024 until the date of payment in full. And you can prepare that order, Ms. Oatman, and submit it under 7 days.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good.
Uh-oh, a lawyer is gonna have to explain to me what happened there. I listened to it. I guess they just won outright? Won outright? Yes, John, I will be doing a stream tomorrow. I think it'll probably be like this time and then maybe a members only later. And oh, over it you had the tanning Barbie. You know what Barbie I had? The one that was pregnant and you could flip her belly and she went back to being flat. And Grim, it's so nice to see you, and this goes for anybody watching or anybody's mind. Remember, if you take a break and you can't be around for a while, that's okay. We still love you. Come on back anytime. Oh, I gotta get the last fucking thing. Last one. Last case. The Barbie was pregnant and you could like flip her belly over. I got it in Florida. I remember it so distinctly. So distinctly. I think it was twin babies that she had. You know what I mean? Okay, last case of the night. Then I gotta go make dinner right. It's gonna be yummy. It's gonna be fun. As long as I make it yum, yum, yum. Okay. I think this is it. Oh, nice, John. That's awesome. And lead paint toys. There are still lead paint toys out there and lead paint. Oh, shit.
Judge said it was a.
Hold on, Jesus. I'm sorry. I didn't mean to cut you off. Please continue. I just read a lot of books. Oh, what has she got back there? Is that yarn?
Please
Is
unmute
that all
her.
yarn?
Judge said it was okay to go with just you guys and not the.
So Kelly, you decided to dress up for us today?
I did in my sweater. It's too cold.
Oh, I do have your client now. Is this, I think this should be, is that Cole?
This should be Mr. Schleier.
Okay.
Carol, last time she came in a sweatshirt and.
Oh.
That was putting of term.
Oh, I think you need to be in that sweatshirt today, sister.
I
All right,
know.
let me go ahead and call this here real quick.
Thank you.
All right, the 37th Circuit Court is in session with the Honorable Brian K. Kirkham presiding. Today is Tuesday, January 21st, 2025 at 1:33 p.m. for 2024-2727 DM. Paul Schleier versus Kayla Schleier. Attorney Podolsky is for the plaintiff and Attorney McKenzie for the defendant.
Well, good afternoon to everyone.
Good afternoon, Your Honor.
And I have a note that your case is settled prior to mediation. Is that accurate?
No,
Well,
not quite, not quite. All right, the
if you want to go
parties
ahead,
are-
Carol. Yeah, go ahead.
All right, the parties are chatting about possible reconciliation. My client, Mrs. Schleier, has requested that this matter be put off for maybe another month or closer to the 6-month mark. 6-month mark will be around the third week of March. I think that would be a good idea because I think either the parties will reconcile or Mr. Schleier will, by that point, have had the opportunity to come up with a plan to buy out Mr. Schleier's interest in the marital residence. So they need a little bit more time, Your Honor, and I think it's worth their while and worth the court's time to adjourn this to maybe, I don't know, 1st of March, mid-March. What do you suggest, Ms. Podolsky?
I would just have one date that I'm unavailable in March, but what Carol is stating is accurate. The issues are resolved if, unfortunately, this does proceed and ultimately resolve in a divorce, but with just that exception of how my client would be refinancing the house.
Okay. Why don't I put about mid-March and we'll get you back in and see where we're at that time.
Thank you, Your Honor.
Thank
Okay.
you.
We'll let you go and not take up any more of your time.
Thank you, Your Honor.
Have a good day.
All right,
You too.
thank you. I'm gonna close it here.
Oh my God. Finally, love prevails. Love prevails. Or refinancing, you know, one or the other. Are you done, Jesus? I don't want to rush you, but I feel like you might be done. Oh, just a closing cutscene of the judge's chair, empty.
Hello,
Hi. What's up?
can you hear me, Victor?
Can you hear me?
Yes, I just sent you a message here on Zoom chat. So I removed it at their request since you guys fully settled, and so they're preparing the orders. So we're set for now. We will follow up with Schaefer in about a week or two, see where the orders are.
Thank you so much. I was just trying to read it right back to you and you pulled me in. So it's cool. Thank you so
Okay.
much.
No problem. We'll see you soon.
And that is that. That's all she wrote, ladies and gentlemen. Well, that's all Brian Kirkham wrote today. Interesting cases. Definitely started off with a bit of a bang and a bang outside the marriage. But remember, it was too late. So that's the lesson to be learned. If that baby ain't your baby, go file that with the court right away, or else you may be fucked. I will be back on tomorrow. We will do members only tomorrow as well. And I want you to guys to really keep warm, stay safe. I know the snow's out there. Please, please just stay home. Don't go driving. Yeah, try not to be a stranger too, Grim. But seriously, guys, don't go out driving. Walk, absolutely, but be careful of roads and stay warm and safe. Exactly. Do me a favor. Remember that I love you and I am proud of you, and I will see you in the next video. Okay, bye.
Always down and ready to ride.